In 1920, the same year that Congress enacted the Jones Act, Congress also enacted what's called the Suits in Admiralty Act. The Suits in Admiralty Act allowed injured seamen to sue the United States when they were injured on vessels owned or operated by the United States. The statute of limitation, or the period of time that you need to make a claim in for the Suits in Admiralty Act, is 2 years, which is 1 year less than the 3-year statute of limitation that applies to Jones Act claims and to general maritime law claims. It is very important to realize that 2-year statute applies, or can potentially be applied, in any case involving a United States vessel or a vessel operated on the United States behalf. The Public Vessels Act was passed 6 years later in 1926, and with the Clarification Act, clarified that you can sue the United States in these instances of injuries or death on vessels owned or operated by the United States or on the United States behalf. The Suits in Admiralty Act has what's called an exclusivity provision, which applies if an agent of the United States government was operating a ship on the United States behalf and an injury occurred on that ship or vessel. The application of the exclusivity provision in the Suits in Admiralty Act often turns upon whether the company was acting as an agent or not of the United States at the time of the incident. We have litigated this issue as to whether we can pursue a private company in addition to the United States in a number of cases. Determination of agency is often a fact-intensive inquiry. Determining whether a company was acting as an agent of the United States on the day of an incident often requires much investigation and often many depositions to determine whether the company was acting within the scope of any agency relationship, within the scope of any contract that the company had with the United States government. If your lawsuit is limited to a suit against the United States, suit must be filed in federal court and will have a bench trial instead of a jury trial. If your lawsuit can also be pursued against private companies, you can have a jury trial with respect to your claims against the private companies, but a bench or judge trial with respect to your claims against the United States.